All right. All right. So you can have a seat. So again, we talked about that the tax treatment is very flexible in the context of partnerships, right? The question now that I'm going to ask for you, and again, we'll give Ms. Sharp that point there, and Ms. Pickering. The next question to Ms. Mathis is, how do you start a partnership? How do you form a partnership?
Okay, you form a partnership by a partnership agreement, partnership duration, and the last one is partnership by estoppel.
Well, so again, there's two types of partnerships. It can be formed in two ways. One is through what?
Partnership agreement.
And then the other is through what?
The partnership duration.
No. That's ancillary. It's by estoppel. Now, when you say estoppel, and again, if you give me an answer, I expect you to be able to explain that answer. Okay? So, Ms. Mathis, what is partnership by estoppel?
Whenever a third party has a reasonable existing opposed liability, but not partnership rights on the lead partner.
Excuse me, can you repeat that?
When a third person has a reasonable and determined, that word.
What's the word you're talking about here?
DETR, determinedly relied on the representation.
Or when a person has detrimentally relied upon it? Okay, a
relied on the I'm bad with words. Representation that a partner was a non-partner was a part of a partnership.
Okay, so what she's saying is in the context of non-partner agents, right? And she's saying that persons who are not partners, but who hold themselves out to be partners, can be held to actually be a member of that partnership, even though they are not party to the partnership agreement. So again, generally, in order to be a part of a partnership agreement, a partnership, you have to have had what they call a meeting of the minds and have an agreement, right, to be involved in the sharing of both the liabilities and the profits, right? Those are the main things that exist in the context of partnership formation, right? However, a person who, and again, a partnership can be formed by a partnership agreement can be formed by, what means? I'm sorry, Miss Mathis?
Oh, say what means?
Yes, let me, since you did such a good job there, let me have you go ahead and sit down. Ask your colleague, Miss Uzuku, to help you out. Miss Uzuku, help her out. How can you form? We said that the partnership agreement has to be by agreement. The partnership has to be formed by an agreement. But tell me, in what means can this agreement exist? What are the forms for that agreement to exist?
The partnership agreement could be written or oral, unless the statute of frauds requires a written agreement.
Exactly. It can be written, oral, or what? Implied. Implied. Exactly. Okay. Implied. There are what? I'm not finished, Mr. Zuku. Mrs. Zuko, what partnerships must be in writing, though? What partnerships must be in writing? There's a general, in Business Law 1, we studied this called the statute of frauds. Remember? What agreements must be in writing in order for them to be enforced? Mrs. Zuko, you got it? You don't have it? Okay, let's ask for Ms. Sargison. Help her out.
Authorizing partners to transfer interest in real property.
Exactly. Any agreement dealing with the transfer of real property must be in what? Writing. So again, if you have a partnership, right, that's involved in transferring property, the partnership itself must also be in writing in order for that transfer, in order for that that partnership to be valid. All right. So again, that's the and again, a writing doesn't have to be in just paper, right? Ms. Sargison, we're not finished. It can be also in what?
In
Electronic form, right? So what? It could be a form of an agreement. A video. What else? What else? Text message, right? An email, right?
Yes.
It's all. This is in documented form. You see what I mean? All right. Okay. Thank you very much, Ms. Sargison. All right.
555.
Thank you. So again, give me an example of, again, the other thing we talked about is that, again, some partners who are not agents can be implied to be, again, some partners who are not partners, right, because they're not a part of the agreement, can be implied to be a partner when certain things happen that causes another person who's not a partner to detrimentally rely upon that person being a partner. Give me that case in point 2.4, Miss Suzuki. I'll give you another chance. Miss Suzuki, give me that 2.4. 2.4, case in point. 2.4, case in point.
Jackson Paper Manufacturing Company makes paper that is sued by Stonewall Packaging LLC. Jackson and Stonewall have officers and directors in common, and they share employees, property, and equipment. In reliance on Jackson's business reputation, Best Cartage Inc. agreed to provide transportation services for Stonewall and bought 37 tractor trailers to use in fulfilling the contract. Best provided the services until Stonewall terminated the agreement. Best filed a suit for breach of contract against Stonewall and Jackson, seeking $678,000 in unpaid invoices and consequential damages of $1,336,000 for the tractor trailer they had purchased. Best argued that Stonewall and Jackson had a partnership by Estocker. The court agreed, finding that defendants combined labor, skills, and property to advance their alleged business partnership. Jackson had negotiated the agreement on Stonewall's behalf, and the news release stated that Jackson had served tax incentives for Stonewall. Jackson also had bought real estate equipment and general supplies for Stonewall with no expectation of payment from Stonewall to Jackson. This was sufficient to prove a partnership by Estocker.
So again, this is very important for you to understand that if you hold yourself out as being partners, right? If you're combining, assets, like you have some workers and somebody else has some workers, and you all basically have your workers work together in joint projects. You all are using the same offices, you're using the same equipment, then there could be, by outside parties, people who are not privileged to your arrangement, people on the outside can assume that obviously they must be working together, right? Combining forces in order to be able to share profits and liabilities. That's what establishes a profit. I mean, that's what establishes a partnership, right? So if you're doing things that look like that, then you want to be careful, because if somebody sues, again, one of the individuals, they can actually hold you also jointly liable. So you want to be careful if you have these types of relationships to make it clear to the people on the outside what the relationship is. In some cases, you're going to want to have partnerships, right? You're going to want to have joint ventures, which we'll talk about in a bit. But when you do that, you want to make it clear to the people with whom you're dealing what the relationships are. Because if you don't make it clear, if they make an assumption that's based upon reason, then they will be held to be correct. And you will be held liable, possibly, for the liabilities of your colleague who may or may not be your partner. Okay? Very good. Thank you very much. So let's talk about the rights of partners. What are the rights of a partner? The rights of a partner, Miss Miller.
In a general partnership, all partners have equal rights, unless in managing the partnership, per the uniform.
6 o'clock.
Thank you.
Unless the partner agree otherwise. That
So let's hit off the main pieces before we divide them up or dissect them. Okay? So what are the rights of a partner?
the actual rights are
They're in various areas. Management,
interest in the partnership,
interest in the partnership, compensation,
inspection of books, accounting, and property.
Okay, those are the rights. Again, those are the general areas that define the rights. Okay, so let's break this down. Ms. Miller, give me, what are the management rights of a partner in a partnership?
A manager's right in a partnership.
What do the management rights consist of?
Okay, he will, management each one vote, majority wins, need unanimous consent for some actions, the interest in the partnership equal property losses shared as proper share.
So again, the key issue is that in a partnership, all members of the partnership have the right to be involved in management decisions. That's the whole idea of having a partnership, right? Everybody has a right to be involved in management, right? However, the management, and each one has a vote, has one vote in the matter, unless the partnership agrees otherwise. Everybody has a one equal vote, regardless of their proportional share in the firm. This is really important to know. Because, again, one might assume that, hey, going back to this example, Ms. Ray, Ms. Powell, and Mr. Young, you might think that since Ms. Ray has a 40% share of the partnership, that she might have what in terms of the management?
The most input.
Exactly, the most input. She owns 40%. But that's not the case. Even if you have 1% share in a partnership, you have the same vote, right? Unless agreed otherwise, you have the same vote as somebody who has 99%. All right? So again, that's another benefit, depending upon how you look at it, a benefit of a partnership. Thank you. You can see.
Low battery.
Low battery? Okay. You have a iPhone battery?
I have it's a case though, so you
Yeah.
have to take all this off. It's just a case.
Do
And
you have a cord?
mm-mm.
No cord? Okay.
I just have a charging case.
Do you have a cord?
iPhone. Oh, thank you.
All right. Next is the issue of, and again, going back to management decisions. There for some ordinary decisions, the majority rule controls, right? As we discussed before, right? Unless otherwise specified in the agreement. Decisions that significantly affect the nature of the partnership or that are outside the ordinary course of the partnership, however, require a unanimous consent. Unanimous consent. And the things that involve decisions that require a unanimous consent include, for example, the alteration of the essential nature of the firm. So if the firm is going to dramatically change what it does, right? If it changes the capital structure. So if, for example, you have capital being divided up as we have here, and they want to change the structure of the capital in terms of what amount that each person has to put in, you may have to have the unanimous consent in order to amend the terms of the partnership agreement. So if the partnership agreement spells out who are the members of the partners, or other terms, in terms of the duration of the partnership, rather, then they will have to get a unanimous consent. Or, for example, to admit a new partner. Again, unanimous consent. Unanimous means what? Everybody. So again, you can't add a new member to the partnership. Thank you. You can't add a new member unless you get, again, everybody's consent. Again, also as we said, also to engage in a completely new business, to assign partnership property to the trust, right, for the benefit of creditors, or to allow a creditor to enter into judgment against the partnership for an agreed sum without the use of legal proceedings. So if we want to basically make a deal with somebody with whom we owe money, and you want to assign this property to a trust for the benefit of a person to whom you owe money, everybody has to concede to that and consent. To dispose of the partnership's goodwill. And again, goodwill is essentially your reputation. So again, if you have, or even intellectual property can be considered goodwill. We'll talk a little bit about that. And also to submit the partnership claims to arbitration. So again, if you have a claim that instead of going to court, you decide you want to go to an arbitrator, that has to be decided by all the partners. And to undertake any act that would make further conduct of the partnership business impossible. So if you do something that essentially makes the partnership, so again, you say, okay, well, I want to essentially sell all the assets. Again, that is something that will, if done, essentially may make the partnership not possible to run. So again, that's one of the rights. Let's talk about the interest. Again, the rights related to the interest in the partnership. What is the issue involved in the interest of the partnership, Mr. McKenzie?
Each partner is entitled to the
Proportion
of the business profits and losses that is specified in the partnership agreement. If the agreement does not
apportion
profits, indicate how much the profits will be shared. The UPA.
That's what apportionment of profits mean. Apportionment of profits is essentially to determine how much of the profits will one person be given versus the other. So if there is no types of documentation that spells that out in the partnership, then the Uniform Partnership Act provides what? How will the profits be shared according to the UPA?
Equally.
Equally, exactly. So again, in your partnership agreement, if you don't spell out how your partnership profits will be divided up, then the law will deem that everybody gets an equal share. So you need to be very careful. If you want to give, one partner more because they put in more money, you need to spell that out. All right.
At the beginning.
Losses also will be shared the same way as profits. Okay. Thank you, Mr. McKenzie. In terms of compensation, what is the concept related to compensation? Mr. Jackson. Mr. Jackson here?
Yeah. The vote for compensation is devoting time, skills, and energy to the partnership business. Is the partner's duty in general is not the compensable service. Rather, as mentioned, a partner's income from the partnership takes the form of a distribution of profits according to the partner's share in the business.
So, this is very important. Because most people are going to go into business for the purposes of doing what? Being paid, right? However, in the context of your partnership, you got to be clear that just doing the ordinary duties of the partnership, thank you, may not guarantee you the compensation from the partnership, unless the partnership agreement spells it out otherwise, right? So in the context of a law firm, for example, if a law firm in general, if a group of lawyers go into the practice of law together, each one of them, again, it's assumed that they're going to dedicate their time, skill, and energy to basically advance the law firm's business. However, so again, if they get a client and the client pays them some money, the way generally law firms who are partnerships work is that the compensation is divided up equally, as opposed to the partner getting an hourly rate that's guaranteed by the firm. This can be changed, however, by the partnership agreement. So in some cases, what may happen is that the partnership may say, okay, you will get a lower hourly rate and then get a share of the partner or share of the profit after the conclusion of the term. So at the end of the year, you get a profit sharing. That's how some firms may work, right? So instead of if every partner has, let's say, an hourly rate of $500 an hour, instead of them getting $500 an hour, they might agree to get a lower amount, let's say $100 an hour, right? So they get $100 an hour for each one of the hours that they bill, but at the end of the year, they get a share of the profits that relate to their share of the company, all right? So again, that's how that works, all right? Another is, again, we talked about inspection of books. That just generally means that the partners are eligible to look at the books, look at the profits and the losses, or the revenue and the expenses. Look at who are the other members of the business. Again, those are they also, if they fear that some of the money is being misused, they can ask for, again, an accounting of all the money, right? And they also, again, have the right to, again, use property that is purchased by the partners. Each one can use or possess the partner, the property, but however, only on behalf of the partnership, right? So again, you have no right to sell or mortgage or transfer the property to another automatically. You're not the co-owner of the partnership, of the property, partnership property. So therefore, if it's a car, for example, so if everybody, if this is a car that's owned by the partnership, and you guys are in the business of selling, let's say selling, computers. So anybody can use the car in order to go to an appointment for the purpose of selling that computer. However, if somebody wants to go out on his own, and use a car in order to go out, well, that's not a part of the partnership purpose, right? Unless you guys are saying, okay, we're going to go out as a team, as a way of, creating team, morale building and team working skills. But if you're just going out individually to just enjoy yourself, that is not a partnership liability. And so therefore, if you do it, then you will have to actually pay the partnership for the use of that partnership property, all right? All right, so those are the things, again, we talked about the counting and property. Those are the things related to the rights of a partnership. Now, let us talk about the duties and liabilities. We talked about what the rights of a partner is. Now, let us talk about the duties and liabilities of a partner. What are the duties and liabilities of a partner? Mr. Jackson, you already gave the answer to that, right? That last one. All right, Mr. Todd Young. What are the duties and liabilities of a partner?
Fiduciary duties. Is that true?
6:15.
Thank you. Is that what you're looking for? What are the duties?
I said fiduciary duties.
What are the duties? You just told me fiduciary, that's a general concept. I mean, what are the specific duties?
Oh, so you want me to, okay. The fiduciary duties that a partner owes to the partnership and other partners are the duty of care and the duty of loyalty.
So, answer. We need to know that first and foremost, as was discussed earlier, that each partner is an agent of the other partners, right? So again, they are fiduciaries and general agents of one another. And again, a fiduciary is what, Mr. Young?
What I just said?
Pardon me? What is a fiduciary?
Fiduciary duty. Are you talking that?
I'm asking you, what is a fiduciary? What is the, you use the word fiduciary, what is it? Fiduciary.
No clue.
Well, Mr. Payne, help him out. What is a fiduciary?
Fiduciary is a person that's like a representative of the company or a trustee.
Exactly. A fiduciary is somebody who is there to represent, but it's also, it comes along, it's not just an agent, but it comes along with an added responsibility. and that is the ability to actually transact business on behalf, and you have to do it in a way that safeguards the interests of that other person. Well, no, not a manager. It is almost kind of like a trustee, right? So if I have property of yours, right, then I have to act like it's my property, meaning in terms of protect it like it's mine, but I can't use it for my own benefit. You see what I mean? That's what a fiduciary means. Okay. So again, the duty of care and the duty of loyalty. All right. So again, that's what we talk about. Again, and the duty of care is limited to what, Mr. Young?
Limited to refraining from grossly negligent or reckless conduct, intentional misconduct, or a knowing violation of law.
Okay. So again, simple negligence or an honest error in judgment involved in the partnership business is not going to help. Is not going to be enough to hold that partner individually liable. So he can only be individually liable if he commits a what, Mr. Young? An act of gross what?
Gross negligence.
Or recklessness.
Or
intentional misconduct, right?
Or violation.
Or violation of law. So in the context of give me an example. Well, I'll give you an example. An example of let's say, intentional misconduct. If we are again going back to selling computers, if we're selling computers and one of your customers, basically insults you and say, you dirty, rotten, Donald Trump lover or something like that. You know what I mean? And you get so insulted by being called a Donald Trump lover that you take her computer and you throw it on the ground and smash it up, right? That will be a what?
That's intentional misconduct.
Intentional misconduct. That's intentional misconduct, right? It may also be a violation of law, depending upon, again, in some states, if you smash up somebody's cell phone,
620.
thank you. In some states, destroying somebody's cell phone is a criminal offense. Yeah, you got to be careful of that. You got to be careful of that. So you can be held criminally liable if you take somebody's cell phone and throw it on the ground or smash it up and throw it out the window or anything like that.
Right.
So you got to be very careful of that. And this is something that is oftentimes used in domestic relations issues, and so oftentimes against men, but nevertheless it can be used equally against women as well. But men find themselves being targeted by that particular offense, so be careful. Yes, ma'am.
I have a question. Would Enron be like their trust, their fiduciary trust was broken when it was just intentionally misconduct?
Exactly. That's another example where partners individually should have been held liable for that situation in the context of Enron. All right, thank you, Mr. Payne and Mr. Young. You guys can have a seat. All right. Next, in the context of we talk about the liability of partners, right?
Yes.
One significant disadvantage associated with a traditional partnership is that the partners are what? Are what? Mr. Brown, Mr. Jaquan Brown. Partners are what?
Could you repeat the question one more time?
I said that, tell me, in terms of liability, how are partners considered in the context, how are partners treated in the context of liability for the partnership?
They both have joint liability.
Joint liability, so what does that mean?
So what one partner does, it also affects the other partner.
Okay. So give me an example of that.
Of joint liability.
Mm-hmm.
So if you sue one person in a partnership, you can sue both.
Exactly. All right. So this means that if we are, let's say, again, selling computers, Mr. Young here has smashed the computer, right, of Miss Pickering, because Miss Pickering called him a Donald Trump lover, and he got so mad that he may have been a Donald Trump lover. Who knows? No. Well,
No.
hey, everybody has their own right? But he got upset, right? He threw the computer down, smashed it up, right? Miss Pickering says, okay, I'm not only going to sue you, but I'm also going to sue Miss Ray and Miss Powell. Because you all are partners, right? Because you all are what, Mr. Brown?
Joint liability.
Oh, were you standing all the time?
Yes, I was standing. I sat down when you started talking. Yeah, y'all both are joint liability.
Because they're jointly liable, okay? Right? Now tell me what several liability is. So again, you talked about what joint liability is. I'll go ahead and give you a pass to that, Mr. Brown. Mr. McGriff, tell me what several joint and several liability is. Help her out, Miss Mashoud, Dr. Mashoud.
625.
Thank you.
Means that a third party has the option of suing all the parties together jointly or one or more of the partners separately.
So again, give me an example based upon this example I told before. So Ms. Pickering, who is suing, going after Mr. Young for damaging and smashing up her computer after she insulted him. In the previous example, Mr. Brown said they went after Mr. Young, went after Ms. Powell, and Ms. Ray at the same time. Now give me another example using joint and several liability.
Meaning that
Ms. Pickering
can sue Mr. Young individually, and also the members, the partners in the partnership, and also, I guess it doesn't have to be the same time when it means several, right?
Meaning to say, and this is maybe unfortunate, again, it's one of the possible liabilities. Ms. Pickering says, I know Mr. Young doesn't have any money. So why even bother suing Mr. Young, right? But I know because Ms. Ray owns 40% of the partnership, she has bank. So I'm not even going to sue Mr. Young. I'm going to spare Mr. Young. I'm going after the money. I'm going after the money. The money is with Miss Ray. I'm going to sue her. I'm going to sue you, right? Because she has the money. That's what joint and several liability means. You can either sue one, you can sue all, right? Or you can sue the one who's not even involved in that particular matter, right? However, again, going back to this other issue, in that example, as we gave before, in that scenario, because Mr. Young is, again, he committed an act that was considered a violation of the fiduciary of the other partners. Even though Miss Pickering would be seeking to sue Miss Ray for the actions of Mr. Young, because this is something that goes outside of the scope of the partnership, she can use that as a defense and say that Mr. Young committed something that was actually, again, intentionally, it was an act of intentional misconduct. And because it's an act of intentional misconduct, this is not a liability of the partnership, and so therefore the normal rules of joint and several liability would be defeated. Okay? You got to understand this, right? You got to understand this information if you want to be able to protect your assets, all right? Because that's a defense that can save you, all right? So again, going back to, so that's joint and several liabilities. So again, another thing is you got to know is that new partner newly admitted to a existing partnership is not personally liable for any partnership liabilities that incurred before the person became a partner. All right? So going back in this example, let's say that something happened that was just an act of, instead of a intentional act of misconduct, it was a mistake. All the partners were involved in it, and these were the partners initially. And Mr. Dr. Momo became a partner, right, after the mistake happened that Mr. Young committed. Mr. Momo can say, well, look, you know, I'm a partner, but I'm not what? I'm not liable for that mistake. Okay? So again, want to be conscious of that. All right? So now let's talk about the dissolving partnership assets. Dissolving, basically. Okay, we talked about the whole idea of. You guys can have a seat, Dr. Momo. So we talked about Ms. McGriff. Did you get that? You didn't. Okay. So we talked about the disassociation, the disillusionment. So again, how does a partnership end? How does a partnership end, Miss Quinn? Miss Quinn. How does a partnership end? Ms. Dobbins, how does a partnership end? Ms. Dobbins here?
Yes. It can be by notice. 6:30.
Thanks. What is it? What is the termination of a partnership called, Ms. Dobbins? First of all, disassociation, right? And it occurs when what happens?
When one partner ceases to be associated and the partner ceases.
Exactly. All right. So again, although a partner always has the power to disassociate, he or she may not have the right to disassociate.
That's right.
Right? That's he can't. There's a power to disassociate, but he may not have a right to disassociate. So if you disassociate in a way that is not right, is not based upon one of the things that you all have agreed, then you could be held liable to the rest of the partners for the cost of the disassociation. So again, normally the disassociation entitles the partner to have his or her interest purchased by the partnership. It also terminates the partner's actual authority to act for the partnership and to participate in the running of business. The partnership may continue to do business without the disassociated partner. So again, that is disassociation is when one person leaves the partnership. When one person leaves the partnership, that is what is called disassociation. There's another one. There's another form of termination, or there's another form when the entire partnership ceases to exist. In the context of one partner leaving, that is called disassociation. Now, tell me the events, because I don't know if you got that one quite yet, so I'll give you another shot at it, Ms. Dobbins. Give me an event that causes disassociation. What are the events, 5 events that cause disassociation under the Uniform Partnership Act?
There could be notifying the partners.
Mm-hmm. 1.
Due to an event specified in the partnership agreement.
2.
By unanimous vote of the other partners.
3.
By judicial or arbitral order.
Arbitral. Mm-hmm.
Arbitral.
Mm-hmm. 5.
Due to death, incapacity, bankruptcy, or assigning partnership interests for the benefit of creditors.
All right. right. That is. So again, that is and one of the things that happens the most is due to the death of or incapacity of a partner, particularly for older people. When that happens, that partnership may continue, but that partner itself is disassociated. Okay. Again, as was mentioned before, a partner has the power to disassociate at any time, but if he or she does it in an incorrect way, then the partners can sue her or him for wrongfully disassociated. All right, and that's what you have as an example in 2.10. All right, partnership termination. So in addition to the one partner leaving, there's another instance when the partnership ceases to exist itself. Ms. Quinn, let's give you another shot here. Tell me about what happens when the partnership ceases. What is that called, and how does that happen?
So it's called a dissolution, which means the commencement of the wind-up process. Winding up is the actual process of collecting, liquidating, and distributing the partnership assets.
And what things must happen, and what are the things that may require a dissolution versus a disassociation? What are the things?
635.
Thank you. 35, right?
Yes.
All right. What are the things that may automatically require a dissolution or termination of a partnership?
Terms of partnership agreement, voluntary or involuntary withdrawal, the addition of one or more new partners, death of a partner, bankruptcy, or judiciary decree.
All right. So again, these are the things, and again, if any of these things happen, this might require that the partnership basically end outright, okay? So again, another way that the partnership may end is through what, Miss Quinn?
Can you repeat the question?
What's another event that may cause the partnership to end under the UPA?
Illegality or impracticality.
And what does that mean?
In the event it makes an unlawful or partnership to continue its business will result in dissolution. Under the UPA, a court may order dissolution when it becomes obviously impractical for the firm to continue. For instance, if the business can only be operated at a loss, even when one partner has brought a court action seeking to dissolve a partnership, the partnership continues to exist until it is legally dissolved by the court.
Exactly. So again, if going back to the partnership arrangement that we're talking about, Ms. Powell, Ms. Ray, and Mr. Young. So again, Mr. Young made this, let's say, for example, if he didn't do it intentionally, if he didn't slam Ms. Pickering's computer intentionally, but instead he just sneezed and dropped her computer, and it was one of these really expensive computers that cost, tens of thousands of dollars, that had a lot of data on it and are not recoverable. And so, and let's just say it was just like not say $50,000 worth of damages that the partnership would have had to absorb. And in this instance, they say, hey, well, we can no longer, remain partners, right? We need to dissolve this partnership. Does the partnership end immediately, Ms. Quinn?
No.
Right then? Does it happen right after the damage occurs?
No.
No. What has to happen is a what? Is a what? Let me go back to somebody who does not have a mark by their name. Ms. McGriff, what happens?
Can you repeat the question?
What happens if once they decide they're going to dissolve? What happens?
I think the court has to decide whether it could be judicially dissolved because its economic purpose is being questioned.
No. What happens in between the time that they decide to dissolve and they actually stop basically doing business outright? What happens?
The partnership continues to exist until it is illegally dissolved by the court or by the parties' agreement.
And what is that called?
It's called.
What happens? Ms. Dobbins, you got it? I mean, I'm sorry, not Ms. Dobbins. Ms. Quinn, do you have it now?
Winding up.
Winding up, exactly. Winding up is what?
The actual process of collecting, liquidating, and distributing the partner's assets.
Exactly. That's what winding up is all about, right? And so again, just think about it. In the context of this business, let's say they had $50,000 in revenue, they have $50,000 in debt, right?
Yeah.
So what has to happen before they quit operating? That's right. They have to pay off, right? All the liability, all the debt, all the bills, right? It's the first thing. And then the context of the revenue that they've generated, they have to make sure what happens with respect to the revenue, that all the services or the products that they were supposed to be selling, that all those were sold, right? All those have gotten out the door, right? And all the computers that they were supposed to be fixed, right? They fixed all the computers. So all the things that the partnership were supposed to be doing, right? Can they go and sell more computers? Or can they agree to fix more computers in the winding up process?
No.
Again, generally, they can only engage in the activities relating to the winding up. They can't do any new business.
640.
Thank you. They can't do any new business. Mean to say, for example, if they have a store, they have a lot of computers, they can sell the computers in that store. They can't order any new computers.
That's correct.
All right? That's what winding up is, okay? So that's what those are the key elements of a partnership. Now, there are also things that are called partnership buy-sell agreements. And these are, again, before entering into a partnership, partners should agree on how the assets will be valued and divided in the event that the partnership dissolves. A buy-sell agreement, sometimes simply called a buyout agreement, provides for one or more partners to buy out the other's assets or the other's interest in the partnership should the situation warrant, right? So again, by establishing what price the assets should be valued at beforehand will eliminate a lot of costly negotiation. So again, that's what we talked about in terms of partnership. But there are other things that we you need to know about, which is called a limited liability partnership. Now, a limited liability partnership is, so again, Ms. Quinn, you got that, but Mr. McGriff, you still didn't get it. What is a limited liability partnership, Ms. McGriff?
A limited liability partnership is a hybrid form of business designed mostly for professionals who normally do business as partners in a partnership.
All right. And they have, and what is an example? Give me an example of an LLP, limited liability partnership. What is an example? Pardon me?
The LLP is especially attractive for professional service firms and family businesses,
So what's an example?
accounting firms,
Such as what?
Ernest and Young.
Exactly. Exactly. Those are examples of LLP. Ernest Young, Pricewaterhouse are limited liability partnership. So they're a partnership, but they operate like a corporation in that, as we said before, in this example here, Ms. Ray has 40% share, right? What they can do is agree that Ms. Ray, who has again, she has 40%. She has 40% of the or she owns 40% of the assets. And so because she owns 40% of the assets and 40% of a loss, she has greater rights than the other people. So again, when a partnership, generally everybody has again, even if you put in more money, you have the same vote and you have the same right to the profits and to the liabilities. But in a limited liability partnership, they can agree that it will be based upon their investment. So their investment will determine their liability. That's what they call limited liability, all right? And so again, it's going to be created similar to a normal partnership, but they're going to be specified in the agreement that this is a limited liability partnership, right? But the limited liability partnership can only be, again, generally limited to professional organizations. Professional organizations. If you're not a professional organization, then you have to be what is called a limited liability company that we'll talk about in the next chapter.
645.
Thank you. So tell me, what is a limited partnership? What is a limited partnership? So again, we'll give you that, Miss McGriff. What is a limited partnership? Let's see, doesn't have a check next to their name. Mr. Young, Todd Young. Limited partnership.
LLP is a...
Not LLP. Limited partnership.
Oh, I didn't.
Section 6, sir. What time is it, Miss Pickering?
646.
Yes.
All right, a limited partnership, okay. Limited partnerships originated in... Second paragraph, yeah. Limited partnerships consist of at least one general partner and one or more limited partners.
So what does that mean? What is a general partner?
The main one, like a main partner.
What does that mean? What is he doing? Or her doing? What is she doing? Help.
Is that like what you said earlier? The agent?
Ms. McCain, help him out.
A general partner assumes management responsibility for the partnership and has full responsibility for the partnership and for all its debts.
Versus a limited partner, Mr. Young.
Limited partner contributes cash and other property and owns an interest in the firm but is not involved in management responsibilities and is not personally liable for partnership debts beyond the amount of his or her investment.
Exactly. So again, you have, that is what, again, some companies are created to allow for people to put in money as a silent partner, for example. They put in money, they don't participate in the management, and they're only liable for the extent of their investment, okay? The rights and the duties of a limited partner and the dissolution are similar, but there's some key elements that are outlined here, all right? Okay. You want to basically commit to memory or definitely documentation, Exhibit 2.2, as well as exhibits earlier, one exhibit earlier, the context of partnership, and that's Exhibit 2.1. All right, we'll go ahead and pause here for a break. And if you want to line up your PowerPoint presentations, you should do so now. All right.
Yeah.
Thank you.